Today, in part 4 of my series on buying and selling businesses, we are going to talk about the long-form asset purchase agreement that most letters of intent are contingent upon, and what all terms are going to be in the asset purchase agreement that you're going to have to negotiate before you close on your deal. Let's do it. When it comes to long-form asset purchase agreements, remember, you've nailed in the LOI terms, you've got your material terms agreed upon. Now you're going to drop those terms into the long-form agreement, but there's all these other things you have to have, all this legal mumbo-jumbo that ends up being super necessary, making things a lot easier in the future by solving problems for you just by having clear communication, because every single scenario will be addressed in a good contract, and that's going to help you avoid litigation. Okay, the 6 terms, the 6 key parts, 6 key pieces of asset purchase agreements. Number 1 is getting those material terms from the LOI into the asset purchase agreement itself, and then putting granular detail behind it. So for example, in the LOI, it might say that the seller agrees to a 2-year non-compete agreement. But in the long form agreement, that could end up being 2.5 pages, because you're going to have a paragraph about, defining what it means to compete. You're going to have to negotiate, okay, how many years, what's the range, how many miles, it turns out that the seller has this other thing going on that was really important to them the whole time, and they didn't know that that was going to be included in the non-compete. So these are the kind of things where you're hammering out the details from the LOI. And I mentioned it before, but if you have sort of a quirky term that's really important to you, you may want to put it in the LOI, so to the extent that you can spell it out in the LOI, so that you don't end up not being able to reach an agreement once you get to the long form asset purchase agreement, because by that time you've brought lawyers in. Okay, LOI you can do without lawyers. It's risky. Use me, I'll help you. Okay, call me. But if you do a deal without an asset purchase agreement, without a lawyer, not the best look. So definitely you're lawyered up at that point. So the point is, you don't want to be waiting until you get to the asset purchase agreement phase to realize the deal's not going to work after you've already paid your lawyer, however many thousands of dollars. Number 2, the second thing that is in asset purchase agreements, second big part of them, are representations and warranties. So each side is going to represent certain things to be true, certain things that they've said during the course of the negotiations to be true, all the financials that have been provided are true and accurate, that the parties have the authority to enter into the agreement, all of those things, and they each get a paragraph in some lovely flowery language. And a lot of times people look at those as boilerplate, but they're not, because they cover you for the most basic things. Oh, the other side lied to you about the financials, during the course of the transaction, and now it turns out that they gave you doctored information or whatever. In addition to a fraud claim, you're going to have a breach of contract claim because they breached their warranties and representations. Number 3 is due diligence, which is a huge part of the asset purchase agreement. So it's going to spell out the timeline for the due diligence, what all specific document requests or items are going to be provided and by when, and what is the standard for whether those items trigger the deal not going through and the contingency being met that there was a due diligence issue, right? So due diligence is basically you're looking at the contingencies from the LOI and you're going, okay, here we go, let's check to see if all those contingencies are true. That's what the due diligence period is. That's the easiest way to explain it. Number 4, the conditions precedent for closing. So again, this is actually spelling out the contingencies. The due diligence is going to talk about the mechanics, the process for how you're going to go about, how the buyer is going to go about getting their due diligence from the seller, getting the documents, and the conditions precedent, 4th point I'm talking about now, that is the just putting in the contract actually the contingencies from the LOI. That's what the conditions precedent are. Number 5, thing that goes into an asset purchase agreement. Anything else? So anything that's important to you, those quirky terms, all of that goes in here. anything that matters to the party. So in a restaurant or a business that's got customer cash flow, a business to consumer business, those businesses are going to have a lag in transaction times. It might be a couple days before the credit card company deposits the money in the accounts, and you'll have to transition the accounts, you'll have to transition the inventory purchases, all of those things. So there's usually a term for that. Non-competes are another big one, and again, there are all sorts of terms, whether there's a seller training period where they stay on and tell you things about the business, any detail that, if you're selling a car, the details around transferring the certificate of title, all those fun things. And number 6 is boilerplate. So the real boilerplates, the stuff at the very end. Things like the anti-waiver clause. You don't waive anything by failing to do anything. So, or the entire agreement. That's a very common one. It basically says that anything that the parties have talked about before doesn't matter. Only what's written down matters. You'll have jurisdiction provisions. Where you're going to litigate this thing. Are there attorney's fees paid by anybody? All those fun details that you see, those will be included in asset purchase agreements. Also, indemnity is usually one of the boilerplates that can be rather long. And sometimes I've seen separate indemnity agreements that can be like 10 to 15 pages just for the indemnity agreement. But at any rate, that's the 6 key terms that are go into the asset purchase agreement. Really, the 6 key areas that are covered in asset purchase agreements. And again, there may be, you could have 80 pages and 100 paragraphs, but those are really the 6 main areas. They're all going to fall into one of those categories. Next time, we are going to talk about the due diligence itself, and then after that, we're going to cover post-closing issues. If anyone has questions or comments, please feel free to let me know, and I will respond the best that I can. I may not like my answer, but I will give you one. And we'll see you next time.